My name is Sean O'Sullivan. Welcome to London International Shipping Week. I understand this is the first event of the week, so think of this as the opening ceremony. A monarch may be skydiving in later, we don't know. But what we do know is we have three excellent speakers, and I have the pleasure of introducing them to you. In order, first will be James Leabeater KC, one of our top shipping silks. He took silk in 2019, and his practice is especially impressive for mixing both high-value project litigation and also lots of shipping work. He has a genuinely international practice. I know that because whenever I ring him, he's always in the Middle East or the Far East. And he's also been involved in some of the biggest shipping cases, including, for example, the Thai prize. He is described in the directories as an exceptional barrister. Tom Stewart is a relatively new face at Four Pump Court, but not among shipping litigators. He seems to have had a mature practice almost from the day he started. He was called in 2011, and I'm amazed, frankly, that he has time to be here to do this talk for you today, because he's supposed to be handling at least 3 cases of mine at the moment. But I'm very pleased he is here. And that's the amazing thing about Tom, that he does just have the ability to get everything done to a very high standard. He is described as absolutely brilliant in the directories, and again, I agree. Heather Maxwell is a senior associate at Pennington Manchester Cooper. She covers all aspects of dry shipping, but also, impressively, also has experience of admiralty work, including container ship fires, wreck removal, and even collisions. I understand that she worked at a P&I club, at the coalface, as it were, for 3 years, so she genuinely knows how to handle these claims on behalf of members, and she has considerable experience with the ICA, which is one of the topics she'll be speaking about today. Penningtons, of course, are well known for doing soybean cases, so you are in very good hands. Now, the other task that I have is to outline to you some assumed facts. So the talks are going to be about soybean cases, as you understand, and this is the scenario which I'd like you to all have in your minds. The vessel, the Well Ventilated, is a ship owned by Seaworthy Shipping Company, and she's time chartered to Free Fuel Limited for a period of 6 months. Free Fuel has in turn subchartered the vessel to Low Profile Limited for a single voyage from Sao Paulo in Brazil to Zhoushan in China with a cargo of soybeans. Both the time charter and the voyage charter include law and jurisdiction clauses in favour of English law and London arbitration, and the time charter also incorporates the interclub agreement. 50,000 metric tonnes of soybeans have been loaded at Sao Paulo, and a bill of lading has been issued naming Chemically Unstable Beans LLC as shipper and High Quality Beans Limited as consignee. High Quality Beans is a company based in China. The bill of lading states on the back that it incorporates the law and jurisdiction clause from the charter party as dated over leaf, although none is in fact identified on the front of the bill. En route to China, the vessel stops at Singapore for bunkers, and while she's there, she's arrested for unpaid bunkers provided to the vessel a month earlier on the instructions of the time charterers, who you now understand why they're called Free Fuel. After a delay of 2 weeks, the vessel is released and she continues on her voyage to China. But on arrival, when the cargo is discharged, surprise, surprise, it's found to be suffering from mould and wetting damage. The consignee, High Quality Beans, and its insurers commenced claims in China against the vessel owners, Seaworthy Shipping, in respect of that cargo damage. And the first instance court in China, and then ultimately the Supreme People's Court, find seaworthy shipping liable in full. What happens next? Well, ladies and gentlemen, start your engines, and I hand over to Mr. Levy.
Thank you, Sean. Can you hear me? Sounds like the microphone's working. Getting nods at the back. So the assumed facts that Sean's just outlined are really common. As you all know, the carriage of soybeans is a massive part of the bulk carriage market. These figures are rough, but they're roughly right. Something like 300 million metric tons of soybeans produced a year. About a third of that in each of Brazil and the US, so they're about 100 million metric tons each. Just over a third of that is consumed annually by China. They have an annual consumption of something like 120 or 130 million tons of soybeans, of which the bulk is imported from Brazil. Something like 70 to 80 million tons goes from Brazil to China every year. The value of the cargo is estimated at £30 billion a year. $30 billion a year. Most of that, as we know, goes to animal feed, particularly for pork. There is some reason, I think, in the next few years, I read, for this to expect these figures to decrease, because the China policy is to increase domestic production and to decrease the amount of soybean in pork feed. So if that does happen, we can expect to see, I would have thought, a significant change in global shipping volumes. But for the moment, it's a massive trade of soybeans going from Brazil to China. And that massive trade has created many, many disputes about which most people in this room will have experience. Penningtons, for example, have been involved recently in two big cases, both of which went to the Court of Appeal, the Tide Prize and Eternal Bliss, both arising out of soybean cargoes, both arising out of soybean cargoes which in truth were probably damaged before loading by excessive moisture, but in relation to which Chinese courts found liability as against head owners for reasons that English courts would not have found. And so you have these massive losses out there, borne in the first instance by head owners and their clubs. And we have a whole wealth of different disputes trying to work out where the liabilities should end up. So, on our assumed facts, we have this poor head owner who's been taking a cargo of soybean to China, find themselves embroiled in arrest proceedings, potential arrest proceedings, and they come to solicitors, perhaps counsel in London, and say, well, hang on, we thought we were carrying this cargo under an English law contract with arbitration in London. Why are we involved in China? What can we do about it? Well, the first thing they can do about it is attempt to get an anti-suit injunction, and that's the focus of my talk. Now, from my experience, and I don't know if this is true empirically, but I suspect it is, my experience, most of this cargo is carried on the Congen Bill 2007 bill of lading, or something like that. And as everyone in this room will know, that is a bill of lading which incorporates, as a matter of English law as the substantive jurisdiction, and London arbitration as the forum where disputes should be resolved. And we have these well-known words, which I put on the screen, which if you've got good eyesight, you'll be able to read. All terms and conditions, liberties and exceptions to the Charter Party, dated as overleaf, including the law and arbitration clause, stroke dispute resolution clause, are hereby incorporated. And there are a lot of cases in the commercial court, and indeed a couple in the Court of Appeal, which decide that that clause, as a matter of English law, is sufficient and efficient to incorporate an arbitration clause and English law into the bill of lading contract, which will bind any third party claiming to be the lawful holder of the bill of lading. So that means, as a matter of English law, it will bind the Chinese receivers. And I've listed some of the cases there. Most recently, the precious sky. As I say, it's well established in English law, and it's well established that even if the person filling out the bill of lading hasn't done it particularly well, it will probably still be effective. So, for example, even if the charter party hasn't been dated on the other side of the bill of lading, so long as there is a bill of lading which is reasonably ascertainable, it will probably be incorporated. So all of that is reasonably well established as a matter of English law. It is also reasonably well established as a matter of English law that in circumstances where you have an arbitration clause of this sort incorporated into the contract of carriage upon which the claim is being brought, for example, in China, it's pretty well established that it's not very difficult to get an anti-suit injunction in London from the commercial court. And you can do it reasonably easily in most circumstances. You can do it reasonably quickly. The law says, and as I set out a summary which comes from the most recent case, Precious Sky, but you can find it in all sorts of other authorities, the claimant must show an arbitration clause applies, quotes, to a high degree of probability. But because we're talking about the construction of well-known terms in the bill of lading, that's not a very difficult test. Next part, providing the application's been made promptly and before foreign proceedings are too far advanced, and an injunction will normally be granted unless there are strong reasons not to do so. So a couple of points there. First of all, as an owner, you do need to move promptly. So as soon as you become aware of the fact that Chinese proceedings will be brought or are being brought substantively, and by that I mean with the aim of having the underlying dispute as to what the cause of the soybean deterioration was, then if you want to get an anti-suit injunction, you need to make that application quite promptly. However, generally speaking, these are not those sorts of cases where you can go off and do it so urgently you don't have to give the other side notice. Generally speaking, in these sorts of cases, you do need to give the other side notice you're going to apply to the English High Court. So the usual way it works is that you might send a letter to the Chinese receiver saying, we are instructed on behalf of the owners, the bill of lading incorporates an arbitration clause. Please confirm that you'll discontinue the Chinese proceedings and arbitrate this dispute in London, otherwise you'll apply for an injunction. Then very usually you get no answer at all, and then you will give them notice that you're going to apply on a particular date to the commercial court, and then you make your application. So you need to do it promptly, but usually you do need to give notice. Now, if you have a bill of lading with an arbitration clause incorporated as a matter of English law, then it's quite difficult for the other side to show that there are strong reasons why an injunction should not be granted. For non-convenience issues about what is the most appropriate venue don't really arise in this context, because as a matter of English law, the English courts say, well, you've decided where your dispute should be determined, and you're stuck with that. Now, the only wrinkle that does arise sometimes in these cases is very often the club standing behind head owners will be required to give some sort of guarantee, a letter of indemnity, a letter of undertaking in relation to the dispute in China in order to get the vessel released. And sometimes we find that clubs, either practically speaking or for other reasons, have to agree that they will stand by or respond to a decision of a Chinese court. So that can raise difficulties. Subject to that, as a matter of English law, pretty easy to get an anti-suit injunction. And I suspect all three of us in the panel, and so Sean hasn't been involved in those cases, which are not at all unusual. Now, from the Chinese perspective, things look very different. From the Chinese perspective, as I understand it, and I've put some citations here in relation to some of the material, from the Chinese law perspective, it's much less likely, as things currently stand in Chinese law, that a congen bill incorporation clause of the sort we saw before will bind an entity that they regard as a third party to the bill of lading, i.e. a receiver in China, because the analysis goes that, well, they've never seen the bill of lading before, they didn't agree to that bill of lading, why should they be expected to stand by the arbitration clause? As a matter of reality, in my experience, Chinese courts do not agree that these words of incorporation will be sufficient to incorporate an arbitration clause. So they say, well, here we have damaged cargo which has been delivered in China. We have jurisdiction over the vessel because we managed to arrest her. We're now going to decide the case. And very often they will decide the case in favour of the Chinese receiver on the basis that the owners cannot prove that the damage was caused by some reason, some issue for which they are not responsible. Now, as a head owner, I go to the Chinese court and I waive my anti-suit injunction. What effect does it have? Not very much, is my understanding. They serve it on the cargo receivers and their insurers and whoever else it is that's involved and say, here you are, London High Court order tells you have to bring your proceedings in London arbitration, subject to a penal notice. What effect does that have? Again, not very much. The general reaction for Chinese cargo owners and insurers is to ignore them. And a recent newsletter published by the well-known Chinese shipping specialist Wang Jing say that the Guangzhou Maritime Court is becoming more willing to give what are, properly speaking, anti-suit injunctions, i.e. an injunction against the head owner from proceeding in London to get an injunction to stop the Chinese proceedings. And so there we are. We are in a battle of anti-suits, a battle of jurisdictions, and how is that going to resolve itself? Well, all I can say somewhat weakly is that the results are difficult to predict. Which is going to be more effective, which is going to be more efficient, is going to depend on the facts of the case. Because if, for example, you have an entirely Chinese-based receiver and insurer, they may be perfectly happy to ignore the English High Court judgment, and it would be the English High Court order, and it's impossible to enforce it. On the other hand, you may have an international entity involved, an international insurer, for example, or in my experience, you might, just by quirk, have a Chinese receiver who has some English connections. For example, and this is a good example from one of my cases, but so someone who has a student at an English university and wants to be able to come to the UK, in those circumstances, they don't want to ignore an order of the High Court because they might find themselves being subject to contempt proceedings in relation to the penal notice. So the consequences of the anti-suiting injunction, how effective it will be, and how the result of the battle of the anti-suits resolves itself are difficult to predict. There is to my mind at least, interesting philosophical debate out there as to how this jurisprudential dispute should be resolved. Tom Raphael wrote an influential article a few years ago with a rather long-winded heading, "Do as you would be done by system transcendent justifications and anti-suit injunctions." And the essence of his article, which is an interesting one, is that as a matter of principle, judicial systems of law should think about how they are viewed internationally. And if another international system of law takes a rational approach to an issue, then it's wrong in principle to injunct someone from seeking to enjoy the benefit of that. So, let's put that into practical perspective here. The argument might be, well, here we are, we have these Chinese receivers who've never seen this bill of lading before, and they never agreed to be bound by it. Why shouldn't they go off to Chinese courts and have their dispute decided there? Because that's permissible under Chinese law. And isn't it wrong then for the London court to injunct them from doing so under pain of a penal notice and potentially being sent to prison if they ignore it, for doing what is, from the Chinese law perspective, entirely rational? Now, as things stand, English law does not accept that argument at all. The English law argument, the English law position, which has most recently been set out by Mr. Justice Andrew Baker in the Joker, in the passage that I quoted there, is that is completely commercially unrealistic. The well-established commercial way of trading these sorts of cargoes is they are traded on bills of lading, which are of standard form and many, many years of existence. And everybody in the trade knows that when you accept a cargo of this sort, you accept it on the basis of a clause which may incorporate English law and arbitration. And as he said, if as a Chinese receiver you don't want to do that, fine. But you construct your transaction in a different way. You arrange for the shipping on your own terms. You take it on a different set of contractual provisions which won't end up in a bill of lading which is subject to English law and under arbitration. And that is why English law says, well, if you've agreed an arbitration clause or you take cargo under a bill of lading of that sort, then you should be bound by the consequences. So that's what I want to say about anti-suit injunctions. I'm now going to pass over to Tom, I think, to talk about a slightly more difficult topic, I would say.
Thanks very much, James. Can I just check that those at the back can hear? And that, excellent, getting thumbs up from all, that's all good. Although we've come up with a series of detailed facts, rather like James, I'm actually only going to be concerned with the final few sentences of those facts and about the claims commenced in China. As James says, it's relatively straightforward to obtain an anti-suit injunction. I've had the perhaps misfortune of trying to resist an anti-suit injunction on these sorts of assumed facts. And I got a Christmas card from the solicitor on the other side that year saying it was a plucky piece of advocacy, which I thought was rather charitable in the circumstances. Needless to say, we lost. It's all well and good once you've got your anti-suit injunction, but what do you do about the existence of an award in China against you, in theory, for the full amount of the cargo claim? What is it that our owners can do in these circumstances? Well, it's reasonably well established that damages will be available against the cargo interest for commencing proceedings in breach of the arbitration agreement. But more interesting is the position of the insurer. So interesting that we didn't even get around to naming them in the assumed facts. An insurer can sometimes be a more attractive, or at least an alternative target for a damages claim if they have assets in another jurisdiction or if they have assets that are more easily obtainable. It opens up the possibility of applying commercial pressure, but also of obtaining some kind of compensation. Now, insurers have no contractual obligation as such to pursue arbitration proceedings in London because they're not themselves a party to the arbitration agreement in the Bill of Lading. But if your instinct is that a subrogated insurer is nevertheless not free to pursue claims wherever they choose, despite the existence of a London arbitration agreement, then you would be right. A subrogated insurer has an equitable obligation to respect the arbitration agreement. This has been described as a derived right obligation, namely where a party seeks to assert in a non-contractual forum a right derived from a contracting party. And the key authority in that regard is J. Bowler, where the Court of Appeal explained that the grant of anti-suit relief is rationalised on a benefit and burden basis. The anti-suit respondent cannot enjoy the benefit of the derived right without complying with the associated obligation to pursue the right only in the contractual forum. There's also something known as the inconsistent claim obligation, where a party denies it is bound by the jurisdiction clause contained in the contract, but nevertheless seeks to enforce the right arising under a contract. That is said to be oppressive or vexatious behaviour entitling a party to anti-suit relief. And the main authority, main recent authority in that regard is the Archagalos Gabriel, apologies for pronunciation, 2022 Lloyd's Rep 317, where Cockerell J discussed the type of situation, explaining that it would be invidious to permit someone who is invoking a contract as the basis for its claim to do so otherwise than in accordance with the jurisdictional regime of the contract to which they have either themselves agreed or to which they claim some right to enforce. And there's a recent summary of both of these types of obligation, the derived right obligation, the inconsistent claim obligation in the anti-suit context. See Mr. Justice Foxon in QBE Europe SA against Generali España de Seguros 2023 in the Lloyd's Law Reports Insurance and Reinsurance 192. That's it from the anti-suit perspective. James, remind me, I've put some of these cases up to save people noting it all down. So that's briefly the grounds on which you might obtain anti-suit relief. How does that help our owner in this situation actually obtain some compensation for the fact that they have found themselves at the wrong end of an award in China? For this, we need to look at the Frio Dolphin, which is a relatively recent case, but one which is very rapidly gaining ground as an extra tool in the armoury of vessel owners finding themselves in these sorts of situations. In that case, the cargo insurers were subrogated to the claim of the consignees and brought proceedings against Lavinia Corporation in Spain, apparently in the wrong belief that Lavinia was the carrier, when in fact they were the managers and the charter of the vessel. Lavinia incurred costs in excess of, I think, €100,000 in challenging jurisdiction in Spain, and those costs were unrecoverable in the Spanish proceedings, save for about €8,000. The consignee and the cargo insurers commenced arbitration proceedings against the carrier, who in turn counterclaimed for the unrecoverable costs of Lavinia. It was agreed that the insurers had no contractual obligation to arbitrate. Lavinia were the managers and not themselves party to the arbitration agreement, but there was no question on the appeal to the High Court that the insurer was nevertheless in breach of an equitable obligation to arbitrate in London on the basis of what was described as an extended DRO derived rights situation. The point was the same. The right asserted by the anti-suit applicant was an equitable right not to be sued in respect of a particular claim otherwise than in accordance with the forum agreement. Now, as to the availability of compensation, Sir Michael Burton decided that there was a distinction to be drawn between inconsistent claim situations and derived right situations. He found that damages were not available in breach of an ICO because an ICO arises from the inherent jurisdiction of the court to restrain vexatious proceedings, rather than a breach of an obligation. Damages, or rather equitable compensation, are available, however, for breach of a DRO. The judge accepted the powerful case put forward by the very able counsel and noted that there were no authorities which stood in his way in concluding that there should be equitable compensation for breach. Now, that was a first instance judgment, and although permission was given for further appeal, the matter was not pursued. But as I say, the availability of equitable compensation in these situations does seem to have taken root. And I know from other members of chambers that the Frio Dolphin has been followed in arbitration awards, and I'm not aware of any authorities doubting it. Indeed, it was referred to in the recent judgment in the Prestige numbers 3 and 4 by the Court of Appeal, although the judgment itself doesn't say exactly what the Court of Appeal made of it. But if anybody does have any light they can shed on that, I would be very grateful to hear it after today's talks. So how does that help here? Well, we have a relatively straightforward fact pattern here, where claims have been commenced in China and the insurer's claims are likely to be in breach of a derived right obligation to pursue claims in London arbitration. Indeed, if anything, this case is stronger than that in the Frio Dolphin, since in this case the insurer's actions have caused loss to the owners themselves, who are the contractual party to the bill of lading, rather than the managers, as was the position in the Frio Dolphin. Perhaps the most vexed question, however, is how much the owners could expect to obtain by way of compensation. Now, here, Seaworthy Shipping, our owners, have been found liable in China in full And there are three possibilities, probably more, but three main possibilities in terms of the quantum of the compensation they might expect to recover. First, there seems little doubt that they could recover the costs of defending the foreign proceedings or of resisting enforcement. The second possibility is that they might obtain damages for loss of what would have been a better outcome on the merits had the case been determined in accordance with the arbitration agreement, as contrasted with the outcome in China. Now, one can see the justification of this, because had the insurers complied with their equitable obligation to pursue the claims in London arbitration, the result might well have been different. But there are obvious practical difficulties with this as a measure of damages, not least in terms of how you decide what the difference actually is. Do you have to go through the whole London arbitration in full with all of the expert evidence before you know the outcome? And we know with soybean cases in particular that the outcomes almost always depend on detailed factual and expert evidence. And it's not always straightforward to know exactly what the merits are until one's gone through that entire process. The third option is that the owners might obtain an award for the full amount of any sums awarded against them in China. And there is some support for that in the Alexandros T 2014 2 Lloyd's Rep 544, where it was suggested that the breach lies in bringing the proceedings abroad at all, so that it is irrelevant what would have happened in England, because all that matters is that there would be no foreign judgment. That, I would suggest, has some considerable merit as an outcome, not least because it avoids the practical difficulties of what then happens with the London arbitration. The owners can obtain a full award for the amount of any sums awarded against them in China, and then there may separately be an award against them in the London arbitration for the cargo claim, but that can be dealt with on its own merits and in its own right. But the point is contentious. There's a discussion of it in Tom Raphael's book on anti-suit relief. It's not a straightforward question, and as far as I'm aware, there's no authority at the moment that deals with that, and unfortunately today is not the place to resolve that next question. There are also likely to be issues with enforcement of any award. James has already touched on the difficulties that one can find with companies based in China, but that may or may not be a commercial driver as to whether one seeks to obtain this relief at all, or whether one simply keeps it up the sleeve as an opportunity, as a possibility, as and when assets may or may not be identified that could be attached. That was a bit of a whistle-stop tour of equitable compensation, but I hope it gives some idea of the sorts of issues that arise and of the utility of that for owners finding themselves in this situation, whether with soybean cargoes or more generally. And Heather is now going to talk about the position under the charter party chain.
Can I just check you can hear me fine at the back? Yeah. Well, thank you all for being here so early on Monday. We do appreciate it. So our ship owner is going to be quite out of pocket by this point, assuming none of what we've run through earlier has been successful. So his probably next step of recourse is going to be under the ICA. And I'm sure everybody here is very familiar with the Interclub agreement, but I will give it a little bit of background for context. It's a forum for resolving cargo claims, and it came out of an agreement between the major P&I clubs in an attempt to reduce the litigation between owners and charter members specifically using the NIP form. And its main purpose is to allow the parties to settle their cargo claims on a mechanical and formulaic approach, where there's a clear regime for allocating liability. The first version was published in 1970, and there have been subsequent amendments since in 84, 96, and 2011, which is the most frequently seen version and the one that we will be looking at today. And it's definitely quite a rough and ready agreement, and has previously been described by the court as an agreement which is primarily for the benefit of the respective parties' insurers, that is, of the character of a knock-for-knock agreement. It has advantages and disadvantages for ship owners, but it is intended to work in that way. It solves insurance problems, and it's not concerned with such considerations as hardship or lack of moral culpability. And we've assumed for the purpose of the talk today that the 2011 version is properly incorporated into the charter party between owners and their time charterers, so I'll move on to apportionment. So the liability regime in the ICA is contained within Clause 8 and is broadly as follows, with owners being 100% responsible for claims where they arise out of matters within the owner's sphere of responsibility, so seaworthiness, error, fault in navigation or management of the vessel, unless that unseaworthiness was caused by cargo handling operations, in which case the charterer will be fully responsible. The charterers will be 100% responsible for claims arising out of cargo handling operations, unless responsibility for those cargo operations was transferred contractually to the master, in which case liability will be shared 50-50, or the problems with the cargo operations was caused by the unseaworthiness of the vessel, in which case it will be 100% for owners. Claims for shortage and overcarriage are split 50-50. And then you have the sweep-up provision at Clause 8D, which states that all other claims are apportioned 50-50 between the parties unless there is clear and irrefutable evidence that the claim arose out of the act or neglect of the other, in which case that party bears 100%. And it's this Clause 8D that we will focus on today, taking into account the facts, and this being a case of cargo damage caused by inherent vice. And throughout the session so far, we have really focused on the position for the ship owner, but I think with the ICA, it does make sense to look at the arguments holistically, so we will also consider the charterer's position as well. It's a precondition of apportionment and recovery that the underlying cargo claim has been properly settled or compromised and paid in accordance with Clause 4, and this point is often taken as a primary defence by the charterer against an owner's claim under the ICA. And giving some thought to the cargo claim in this case, it's common ground that an owner should have, in theory, a complete defence to the claim for inherent vice and forbid lading. And so the fact that the owner is seeking to recover quite a large claim from the charterers in those circumstances often gives rise to the argument that it was not properly settled or compromised. However, I'm not sure that this has actually ever been successfully run, at least in this context. And it was most recently dealt with by the tribunal in London Arbitration 1022, where the charterers took the position that the owners had not taken all available defences in China and that they failed to pursue an effective settlement strategy. The tribunal rejected this argument pretty much straight off, and they found that all that was required to overcome this hurdle was that the claim had been settled in good faith for reasons founded upon a genuine perception of the merits of the claim at the time, which would make it properly settled and compromised for the purposes of the RCA. Of course, in our set of assumed facts, the claim was not in fact settled with the Chinese receivers, but it was paid out following a judgment or final judgment by the local courts. So there may be some very limited mileage in the point that had the owners settled early, they may have got a discount on the claim and not incurred all the expensive court fees. But I don't think a tribunal would consider that to be enough for an owner to be on the wrong side of Clause 4. So we'll move forward on the basis that the claim is properly settled and compromised, and we will look at the apportionment of liability under Clause 8. I'll whiz through Clause 8b very quickly. It is often pleaded as the primary argument in inherent vice cases, I think because the starting presumption is that the charge will be 100% liable. However, it is a bit of a non-starter in this case. It's quite clear that Clause 8b is intended to cover situations where the cargo is damaged during the course of cargo operations, whereas in this case the cargo suffers damage by way of its microbiological instability. And this is where the tribunal in 1022 also landed. So the real fight, as I alluded to earlier, is going to be under Clause 8d, which provides that claims arising out of Any other causes are to be apportioned on a 50-50 basis unless there is clear and irrefutable evidence that the claim arose out of the act or neglect of one party, in which case that party will bear 100%. And the 2017 case, Court of Appeal case, of the Yangtze Sinhua is often cited by ship owners as authority for the argument that simply by a charterer ordering a vessel to load a cargo of soybeans, this is an act for the purpose of Clause 8D, and therefore the charterer should be 100% responsible for any resulting cargo claim. I find this argument a little bit difficult to follow for reasons that I'll go into shortly, but it has and will continue to be argued until probably there's another reported case which deals with this point specifically. So I'll run through the facts of the Yangtze quickly. The vessel was chartered for a trip from South America to Iran carrying soybean meal. She arrived off Iran in December 2012 and was ordered by the charterers to wait off the discharge port for 4 months while they waited for payment. The cargo was found damaged during discharge, and it was a finding of fact by the tribunal that the damage was caused by a combination of the inherent properties of the cargo together with the prolonged period of anchor. And it was common ground between the parties that the apportionment should be considered under Clause 8D. And the legal issue that arose out of this case was whether the word act, seen in 8D, ought to take into account fault, breach, or neglect. And the tribunal concluded that, as a point of law, it did not, and they found that this was a case where the ICA must regard the charterer's decisions as an act out of which the claim arose, and so the charterers were found liable for 100% under Clause 8D. But bear in mind there was no breach of the charter party here. Soybeans are a lawful cargo, were a lawful cargo, and the charterers were entitled to order the vessel to wait off the discharge port. But the tribunal held that the combination of factors was an act nonetheless. The case was appealed all the way up to the Court of Appeal in front of Lord Justices Longmore, Hamblin and Henderson. And the Court of Appeal upheld the tribunal and also the High Court's ruling that the word act should be given its natural meaning and does not require an element of culpability or fault. So turning back to our case, the additional 2-week delay here was caused by the charterer's free fuels failure to pay for bunkers previously stemmed on the vessel. And assuming that delay had a positive effect on the deterioration of the cargo, then there's a strong argument to be made that the claim arose out of an act or more likely a neglect of the charterer. And so in our case, I don't see that it would be particularly difficult to persuade a tribunal to find that the charterers were 100% liable for the claim under Clause 8D. But what if there was no additional aggravating factor? The vessel loaded a cargo of soybeans, which were within spec. She set sail, there was no more than a couple of days delay at berthing as normal, but the cargo still overheated and was damaged. How would that claim be apportioned? Because in that case, the owners will have to say that the act for the purpose of 8D is the charterer's order to load a cargo of soybeans, which is arguably quite a stretch. And of course, it will depend who you're acting for as to how strongly you make these arguments. But this point was partly addressed over to by the Court of Appeal, as submissions were put forward in front of their lordships that if they were to determine that an act does not have to be construed as a culpable act, then it would follow that the order given by a charterer to load a particular cargo at a particular port would constitute an act for the purpose of Clause 8D, and that no further factual inquiry would be necessary. But Lord Justice Longmore said that cannot be right, since one cannot inquire into cause of causes, which is quite an unhelpfully cryptic statement. But I think it's clear that he's saying there must still be an investigation into causation. And he does go on to say that many separate areas of the law have worked out how causation should be dealt with, and he gives the example of the implied or express indemnity given to a ship owner following a time charterer's orders. And another point you could potentially make as well is that Clause 8D specifically refers to the actions of either party as causing the claim, not the damage. And so whilst you can argue that the damage is caused by the cargo's microbiological properties, the claim being pursued under the ICA is arguably, and of course absent any further causative action on the charterer's part, caused by the judgment of a foreign court which has seized jurisdiction and has come to a conclusion which is contrary to the position under English law. So taking the example I raised earlier of a non-eventful voyage with no delay, but the cargo is found mouldy on arrival anyway, and the owners have to settle or pay out a large claim in China, then again it could be argued that the cause of the claim is, one, the receivers or their insurers unlawfully bringing a claim in China in breach of the arbitration agreement incorporated into the bills, and or 2, the owner's submission to Chinese law or jurisdiction, where it's commonly known that they would not be able to rely on the inherent vice defence. Now, these are just potential arguments that you can make, and I do think a court would have a degree of sympathy with an owner who's faced a claim in these kind of jurisdictions. So I can't imagine you'd ever see a finding of 100% liability on the owners with these facts. But if you do take the view that the breach of jurisdiction agreement and or the foreign court's judgment is the cause of the claim, then surely that's arguably a case of 50-50 under the ICA. These arguments haven't really been tested or raised really in reported cases, but there have been some interesting comments made by the courts at both instances in the tie prize and the eternal bliss, where although these were not ICA recovery claims that were reported, some surprise was expressed by the courts in those cases that the owners had even incurred liabilities for claims where they should, at least under English law, have had a complete defence. But as we know, the higher courts are usually concerned only with questions of law, and these kind of questions that I'm raising now would usually have been dealt with by a tribunal as a finding of fact and therefore not really open to challenge. But I have heard this view expressed in a talk I attended given by Mr. Robert Bright KC, as he was known then, and of course he's now a sitting commercial judge, so perhaps there will be some more law on this point going forward. And I should add finally that the tribunal in London Arbitration 1022 did find that a distinction could be made between the facts in the Yaxi case, as we ran through earlier, and a situation where there was no additional contributory act or neglect of either party which compounded the situation. And they did say that they were not persuaded that inherent vice was sufficient to make 100% apportionment under clause 8D, absent that additional contributory factor. But of course, arbitrations are not binding, and they're just persuasive, and there may be unreported decisions which have gone the other way, so there's still perhaps an argument to be had. So that brings me to the end of the ICA. Thank you very much for listening. And I think that's the end of our panel session, but we are happy to take questions and discussion points.
So do we have some questions arising out of that? Let's go. You've got a mic somewhere, but yell and probably give me the punchline.
I think it needs to be switched on.
Okay, let's give it. Is it down the bottom? No. That work?
Shubin Shankar from George Fidalo, Bombay. Thanks very much. There's two questions. One is the interclub agreement contains a division of liabilities on the basis of certain faults of some parties. But before the claim reaches the interclub stage, that is, before it reaches a dispute between an owner and a charterer, it has already gone through one round between a cargo claimant and usually a ship owner. And there are several defenses that a ship owner has to a cargo damage claim contained under that version of the Carriage of Goods by Sea Act. Like, for example, say improper lashing. So if this has already passed muster, which means those defenses were not available, which is why the ship owner was found liable and is seeking to recover from the time charter under the interclub agreement. These questions have already been answered. So why are some of these defenses still available at the interclub stage when it should have already been filtered out under the original cargo claim stage?
There is I'm not going to remember the case, but I think there is a case that does cover that specifically, and they do say that you have to treat litigation under the ICA as a new claim in itself. So it doesn't, the court won't necessarily take, or they won't take into account deliberately what the Chinese court found, for example. They won't relitigate that point, they'll just take the facts as they hear them and come to a new determination. I can't remember the case name. Is that?
No, I mean,
Yeah.
I think one of the real difficulties in these cases, from an English law perspective, is that the claim between the cargo interests and the head owners is decided in China. So the Thai prize, which is the case I was involved with, so I know something about, that was a case which is typical of many of these cases, where the soybean defects were caused by moisture existing in the cargo before it was loaded. So it was being stored in hoppers in Brazil, got wet. The moisture was not picked up on testing. The cargo was loaded. The cargo was loaded in a mechanical way, which meant that clouds of dust were being created, so that damaged beans couldn't be seen on loading, so the master didn't know anything about it. The dispute was decided in China between head owners and cargo interests, and the Chinese court found the head owners liable in circumstances where under English law they would not have been liable because this was inherent vice. But the Chinese court found, and I don't think we ever knew the reasoning, but the Chinese court found that head owners were nevertheless liable for 100% of the damage. So the difficulty arises in these cases that you have these findings between cargo interests and head owners which are contrary to the expectations of English law and indeed contrary to the expectations of the Hague or the Hague-Thisbe rules in relation to apportionment.
I think the other thing I would add, stepping away for a moment from soybeans, is that in the example you gave about cargo handling, the position as between the cargo owner, the receiver, and the ship owner may be different from that between the ship owner and the charterer. So that's the whole point of the NYPE division, and the reason why you have 100% going to charterers usually, unless the form's been amended, if cargo handling is the reason, stowage for example, if that's the reason for the damage, poor stowage, then as between your bill of lading holder and your ship owner, it may well be that that is a matter for the ship owner. But as between the ship owner and the charterer, that may have been something that the charterer has taken responsibility for. So you may get a different result, nothing to do with, in this instance, with different courts treating it a different way. You'd get a different result in the English court between those two situations.
Yeah, I don't think you get soybean cargoes damaged on loading. I don't think that happens.
Not by stowage. Well, I've seen them arguments they've been damaged by heating
Yeah,
of oil by the oil tank. So, but again,
that's during the voyage. Though.
Exactly. Yeah, nothing to do with loading. Any other questions? Yes, go on.
Yeah. Another woman from Germany. Hi, I'm just following this argument. Is this not actually the right outcome then? Although the English court would have gone another way than the Chinese court, but for the cargo interest, it was never possible to get actually to the time charterer. And seemingly with the storage issue and the inherent rights issue, the cargo was too wet. And it was nothing to do with the Chinese receiver. It was everything to do with the Brazilian loading operations, having it delayed or whatever. It was too wet and was not right properly. So therefore, okay, it's a bit of a roundabout way, but the Chinese claiming embezzlement, I guess, because that was the no bill of lading with the owner, and then the owner compensating themselves to the wrongdoer.
Does the money end up in the right place, Heather? What do you think?
Yeah, I'm not sure actually.
Can I answer that? Because I have a strong view on this one.
Step back.
So really the problem on this sort of set of facts, as in the Thai prize, the problem lies with the shipper, right, in Brazil. They're the people who've caused the problem by shipping defective soybean without advising anyone of the defects. And so, very simply speaking, the liability should really lie with them. On these sorts of facts, where the Chinese receiver recovers entirely from the head owner, the losses lie on the head owner, who's then left to try and recover from whoever they are. But if you think about the Brazilian shipper's been paid in full for a defective cargo, which is not really, in the grand scheme of things, the correct answer. So one of my arguments in the Thai prize, on which I lost, was that it made sense to be able to pass the liability from head owners to time charterers to voyage charterers. Because the further down that chain of contracts you go, the closer you get to the Brazilian shippers. Eventually, in theory, you will end up with someone who has a contract with the shippers, upon which, in theory at least, they could sue to recover the actual loss from the person that's culpable. But at the moment, it seems to me that I absolutely see the argument that as between the receiver and somebody else, the receiver might not be culpable. But whether that should be the owner that's culpable, I have a bit more difficulty with that.
I think one of the problems is that you might expect the most natural target to be, or the most natural route for that recovery to be via the sale contract.
Yeah.
But that's not an attractive target for a receiver. The ship's there, it can be arrested. The P&I club will put up security. That's the easy and attractive target. So I think English law would say there was nothing wrong with anything the ship owner did. It was your seller you should be shooting your arrows at. The one that interests me, I have to say, is Heather's point, where the question of whether the act of putting on board deteriorating soybeans is itself sufficient to mean 100% liability should be charterers. I mean, speaking for myself, I would have said that if it's clear and irrefutable that that's what happened, so take cases like London Arbitration 1022 and lots of other cases, there are long disputes about whether that's what happened, whether it was to do with the condition of the soybeans, whether it was the way they were carried. You can see that the whole purpose of the ICA may be to say those disputes should end up at 50-50. We shouldn't be having long litigation about whether those are what the causes were. That's not what that subparagraph D is for. But if it's absolutely clear that the problem was that the beans were unstable, is that not an act that should put it to the charterer? You think not, Heather. Tom, do you have a view?
The charterer doesn't select the cargo, does it? He just orders it to be loaded. And if you're looking at who's actually selecting the cargo, it's the shipper. And I'm not necessarily sure that you'd say they're doing that as an agent of the time charterer. So that's another.
No, I see that.
But then you're getting really into the depths of causation.
What do you think, Tom?
But insofar as the contractual regime of the time charter is concerned, if you're looking at which of two parties, owner or time charter, is responsible, there is an act which is the putting on board of cargo, and under the time charter, it's likely to be the time charterer who was responsible for doing that. It seems to me a pretty compelling argument that Sean makes to say that should be sufficient, if the evidence is sufficiently clear to show that that is the cause of everything that's gone wrong.
Does anyone else have a view about that? No? Okay. Just only interests me that it's the whole story. Go on.
Yeah, I've got a couple of questions. One generally, and the other specifically for James. The first is just clarification in China and the inherent vice. Is it that doesn't exist as a defence of law, or is it just they give it very short shrift? That's the first question. And the second one for James is there any right of recourse perhaps under the Bill of Lading against the shipper direct along the lines of the dangerous cargo analogy?
So, point number one, I'm not a Chinese lawyer, but my understanding is that Chinese law does have a concept that inherent vice will be a good defence for the owner. It applies, broadly speaking, principles that we would understand, as applicable. It's just very difficult to establish inherent vice, and they will make findings of facts against the owners unless the owners can show in ways which are almost impossible to do that there wasn't that the damage pre-existed. So they're much less likely to to draw an inference as to how damage occurred. They'll just say, well, if you can't prove it was inherent vice by a picture or something, then we're not going to find it. So they apply the same rules, it's just much more difficult to establish. Question number two: can you go after the shipper for some sort of unlawful? I guess on some facts you might be able to, but I've not seen it successfully answered.
It's really difficult.
Yeah.
The question of whether a cargo that will subject you to delay and other problems at the discharge port is a dangerous cargo. The current law it's probably not, perhaps surprisingly. If it will result in a legal obstacle, so if you as a charterer or a shipper you load a cargo that is contraband in the discharge port, then that could give rise to a claim. But the current position, as I understand, I think it's a decision of Mr. Justice Tomlinson, as he then was, is that it will lead to legal proceedings, i.e. arrest and the like, is not sufficient.
I mean, we argued that at the time prior to the arbitration. I argued that it was legally dangerous cargo, in that it gave rise to a risk of arrest in China and loss. and we didn't appeal that.
Running theme of James' points he ran and lost. But I think we've come to the magic 9:30.
Yeah.
Can I ask you all again to give a round of applause to our wonderful speakers? Thank you. And our thanks also to Pennington's for providing the breakfast and this lovely room. I hope you've all enjoyed it a great deal, and I hope you all have a fantastic time at London International Shipping Week. Thank you all.
Thank you.